I'm Dan Scott. I help families work through the probate process in a stress-free environment to provide certainty and closure when you've lost a loved one. We're going through the A to Z in probate law just as a structure to allow us to walk through a number of ideas and issues in the probate process. Today we're going to talk about the letter D, and we're talking about two things: declination and disclaimer. And they mean completely different things. They just happen to start with the letter D. Declination. When you do a declination, what you're saying is, I've been appointed as the personal representative of this estate, but I declined to serve. I was appointed in the will, but I do not want to serve. And so you file a document called a declination. And what that does is it says to the court, look, I don't want to serve in this capacity. So you're not obligated to serve as the personal representative just because the testator, the person that wrote the will, just because the testator said, you are my personal representative. Sometimes folks decline because they say, look, I don't want the aggravation. I know this family already. They're my family. I don't want to argue with them. Sometimes they decline to serve because they're in a remote location. You know, they've moved to Michigan and the estate's being probated here in Knoxville. Sometimes they decline to serve because of health. You know, sometimes they decline to serve just because they do not want to be bothered. There's any number of reasons, but you don't have to give a reason. You just file an instrument that says, I decline to serve, I'm not going to serve, and then you no longer will be the person that's appointed as a personal representative. This will normally come up when someone contacts you and says, look, you're appointed as a personal representative in this will. Are you willing to serve? And you say, no, I'm not willing to serve. And so they'll say, well, I'll send you a declination that I need you to sign. And so it's an instrument that you file with the court, and then the court appoints somebody else, usually the successor personal representative that's named in the will. Because most wills will say, Johnny Smith is going to be my personal representative. If he's unwilling or unable to serve, then Sally Jones will be my personal representative. So that's what a declination is. Now, a disclaimer is something completely different. Because with a disclaimer, what you're saying is, I don't want what you gave me. Okay, the first is saying, I don't want to serve the way you wanted me to serve. The second is saying, the gift that you gave me, the devise that you gave me in the will, I don't want it, okay? And so you do what's called disclaim your interest, saying, I don't want it. And so, again, you file a document with the probate court called a disclaimer. And if you are disclaiming all of your interest, then that's what you say. I disclaim all of my interest in that property. And you identify the property, the date on which it's going to be effective, and you file that with the court. There can be a scenario where you only have a partial disclaimer, although most of the ones that I've been seeing is a full disclaimer. Now, what happens if you disclaim your interest? You file your disclaimer, then what happens is the probate court looks at the will and says, well, what would have happened under this will if the person that disclaimed their interest died before the testator? If the person that disclaimed their interest died before the testator. And that's how the court will evaluate, well, what happens to this property? Now, rather than a disclaimer, you could receive the property and just transfer it over to somebody else. There may be some ramifications to that, and so you want to get good advice on it, but you could do that. You're entitled to make a gift. Just because you receive property doesn't mean you got to keep it forever. You can make a gift to one of the grandchildren if that's what you're trying to do, or your children, really whatever you wanted to do. So you can disclaim the interest, or you can get it and you can transfer it to somebody else. So there's two letters for today. The declination, which says, I don't want to serve, and the disclaimer that says, I don't want to take what you've given me. I hope this was helpful to you. Hope you found this video helpful to you. And if you did, and you're watching on YouTube, would you go ahead and subscribe to our channel and mash that bell, will you? Slam it, so that we can let you know when we do some more videos. Thanks for watching.